Thanks everyone for joining us for this electronic CPD today. My name is Arti Chetty. I'm a senior associate in the Russell Kennedy Pro Bono practice, and I'm very pleased to introduce today our two exceptional ethics presenters. On my left we have John Corcoran, who is the partner of our Pro Bono practice and also a partner in our property and development team and the former head of the Professional Ethics Committee of the IBA. And on my left, we have Paul Summers, who is a principal in our dispute resolution team, who will take you through our presentation today. Thank you.
Thank you, Arti.
Thank you, Arti.
Hello out there, wherever you are. This is a rather strange experience. We're talking to ourselves here, but we're happy to do this webinar for you. We very much regret that you couldn't all be here at our now famous CLC Day, your CPD Day for the CLC sector, which we very much enjoy hosting every year. But we do know that the topic of ethics is important for you to get your point, and we're very happy to present to you. The session we had prepared for the face-to-face session was pretty much a workshop session where we hope to have a lot of interaction. Obviously, we now can't have that interaction. So we're going to go, when we get through the material, we're going to go through some case studies. And what we'll suggest that you do, particularly those of you that are watching this together, that you perhaps pause after we've gone through the fact situation so you have a discussion yourself before Paul or me give you, hopefully, the right answer to the conundrum.
Or where there's no right answer, some guidance as the sorts of considerations you should be taking into account.
Because very much, I'll get Paul to do a bit of an introduction to ethics, but it is not a black and white area. I think that's one thing that you learn very much in practice. It is truly a grey area. There are some hard and fast principles, but is it really easy to identify what is a conflict, what is confidential? These are very, very complex terms and can have very complex fact situations. So before we get into our case studies, I thought it'd be very good if Paul, who's prepared some excellent material for us here in relation to what is legal ethics. So Paul, perhaps over to you for the introduction.
Okay, thanks John, and welcome folks. All right, so just a bit of background to sort of give some context and some grounding to what it is that we're talking about today. What are legal ethics? So ethics is a branch of philosophy essentially that involves codifying, defending and recommending concepts of right and wrong conduct. Sounds pretty basic, pretty simple, but as we'll find out, not necessarily always so simple and basic to apply. Applied in the context of a profession such as the law, professional ethics encompasses personal and corporate standards of behaviour expected of legal professionals. Professionals exercise specialist knowledge and skill, and how the use of this knowledge should be governed when providing a service to the public can be considered a moral issue, and therefore it's termed professional ethics. It's the ability to make judgments, apply skills and reach informed decisions in situations where the general public cannot, because they've not attained the necessary knowledge and skills. One of the earliest examples of professional ethics is the Hippocratic Oath, to which medical doctors still adhere. So this is nothing unique to lawyers.
And which is on the screen from the 12th century.
Indeed, and that's the exact one, well, a copy of it at any rate. So historically, legal ethics have found expression through court decisions in common law jurisdictions, but in more modern times, legal ethics are mostly enshrined in legislation or a legislative offshoot, such as the professional conduct rules.
And I've got the professional conduct rules here, if you can see me at the moment.
Very good.
And unlike the Hippocratic Oath, which is one page, this has been codified into at least 25 pages.
Which is shorter than its forerunners, but equally as important nonetheless. So other sources of legal ethics are to be found in the Legal Profession Uniform Law Act of 2014, various sets of conduct and regulatory rules. Even the Law Institute of Victoria has a whole series of codes relating to specific fact situations. So there's some information about what the LIV says about codes of ethics, and we have there a listing of all sorts of different types of guidelines which are published with the approval of the LIV Council, and they are published after they've been considered in depth and discussed in depth, and a final guideline is ultimately distilled out of all of that process and then put up on the LIV website. So
I might just expand on that a bit, because the Law Institute has an excellent ethics committee that often is asked by practitioners to determine an ethical question. And these guidelines and rulings come largely from practical experience, actual cases where lawyers were in a quandary as to what the correct ethical rules were. So there is also ethics lawyers at the Law Institute. So if you do have a particular problem, that's the job of those lawyers to help you solve those problems.
that's right. And as we'll come to see in a moment, those ethics lawyers can give rulings to individual practitioners in individual cases on a case-by-case basis, which is of great assistance to that practitioner when they're in a difficult situation. So we've got committee rulings. Well, what are the other sources of legal ethics that practitioners typically use on a day-to-day basis? So we've got colleagues that we might speak to about situations that we're confronted with. We've got CPD, or continuing professional development, presentations such as this and many others that assist and guide practitioners to understand the ever-evolving landscape of ethics. What about gut instinct? That's always a valuable guide to start with in terms of whether you think something is right or wrong, and whether you think it might be something that you need to think about more deeply before taking a certain step or talking about something with somebody.
I might just add one thing there. Just as recently as this week, one of my colleagues came to me with an ethical question. I thought she was completely in the right, but it was a tricky question, and certainly the practitioner on the other side thought there was an issue, but we were able to, and really it turned on the question of whether she was acting in relation to proper instructions from the client, and whether the steps she took as a result of those instructions were appropriate. There was, in the cut and thrust of the matter, there was discussion about whether the conduct of the lawyer should be referred not so much to the ethics committee, but to the regulator of the profession. So and then when it was talked through, the issue quietened down, and a common sense result was achieved.
Yeah. So talking about these sorts of things with colleagues in the first instance is a very valuable approach, and can often help to identify and distill whether in fact there's an issue that needs to be dealt with or not, and some of the ways in which it might be dealt with. So great example, John, and highly recommend that sort of approach.
And I think one other thing before we get on to our... We can't leave out Lawyers Weekly, of course, as a great source of ethical advice. I mean, it perhaps is by default at times, but it does have instances where you often read in Lawyers Weekly about lawyers who have been reprimanded or been fined or worse for their conduct. So at least it just gives you an eye on that edge of the conduct.
That's right. It certainly prompts discussion points and thinking.
Yeah, and before we get into our case studies, I just wanted to mention one other thing. There is a legal conflicts and there are commercial conflicts. Now, in your sector, you may not think that you would have too many commercial conflicts. We might have, as a law firm at Russell Kennedy, we might have a conflict, not strictly a legal conflict, but we may do some work for a client or a subsidiary of a client even though we haven't got a conflict with a matter that might have come to us on behalf of another client in relation to that client's affairs, we may decide not to act for commercial reasons because it would be better that someone could act completely without fear and favour, and better that someone else acted for that individual. So we're talking here predominantly about legal conflicts, but there are commercial conflicts, and I'm sure within the CLC sector you could think of other examples where that similar thing could occur. One of the things that occurred to me was if you were acting for a particular member of a family and you had another person come to see you from the same family, whether there were issues in relation to your knowledge from the first family member of the affairs of the second family member, whether that could give rise or maybe make you uncomfortable in acting for the other person.
And should then also generate some thinking about how that can be managed, if at all. Can it be? And who do you need to speak to, and who do you need to get information or consent from in order for such a situation? So hopefully by going through these case studies now, you'll get some clearer insight into some of the different approaches that are open to you.
Now, rather than have you just sit there reading these case studies, Paul and I thought because they're relatively short, and it's really the relevant facts come out better when we go through them in these settings. Normally, of course, we'll be doing this with you collectively, sitting around a table, but as it is, we'll go through it, each of the case studies. There are about 4 or 5 altogether. The first case study. Russell Kennedy commenced acting for a client who had sustained work-related physical and psychological injuries. The client was seeking compensation. The matter progressed somewhat and a legal proceeding was commenced. Whilst taking the client's instructions for a detailed witness statement, the Russell Kennedy lawyer, Darren, gradually became concerned that the client may not have capacity to give instructions. The client had brought in a new bundle of documents. Darren quickly checks the documents whilst the client is out for a smoko. There was a medical report to the effect that if the client was served with an application to appoint a guardian, it was likely that the client would become suicidal. What should Darren do? What ethical issues arise?
So,
now this is where we suggest you pause if you're in a group situation, and you might have a chat about that fact situation yourself, and then press play again and you'll come back to us.
okay, very good. Thank you, John. Discussion points for case study 1. This particular case study clearly picks up one of the conduct rules in the Solicitors' Conduct Rules of 2015. These are the Victorian Solicitors' Conduct Rules. And 8.1 is fairly short and basic. A solicitor must follow a client's lawful, proper and competent instructions. So 3 concepts there: lawful, proper, competent. So in that context, you need to give some thought to who does a solicitor owe her primary duty to, or his primary duty to in this case. Is it to the client? Is it to the court? Somebody else? What are the primary considerations? So this particular case study was the subject of an LIV ethics ruling, and what the LIV Ethics Committee said in this matter was the following. In the opinion of the Ethics Committee, based on the information presented to it, 1, without informing his client, the lawyer should approach the court at the next administrative mention and disclose the full circumstances to the court and seek guidance as to what further steps should be taken, including the possibility of appointing a litigation guardian. And, in doing so, the law firm should also highlight the potential suicidal tendencies of its client. Now, that was the ruling that was given. Some of you might be thinking, well, what about confidentiality? What about the client's case? What about the client's credibility in their case? And they're all legitimate questions, and there's no easy answer to them. And the LIV committee's ruling is not the right answer. It's a very strongly recommended approach. But you need to think about broader context as well. And there are some concerns about this information, if it's disclosed in the open court setting, as to how that might impact the client and the client's case. So there are some issues to certainly think through and work through in trying to address what the lawyer's obligations are. But certainly there's a concern that the client may not be in a position to give competent instructions, and there needs to be a way found to manage that and convey that information to the court, but perhaps in a way that doesn't disclose all of that level of detail to the extent that the client's position in their case could be prejudiced. All right.
Okay. Well, we'll move on to case number 2. Bob and John, not Paul and John, Bob and John were having a dispute. Russell Kennedy was acting for Bob, a director of Fast Wheels Proprietary Limited. Bob was in dispute with John, the other director of Fast Wheels, in relation to their respective settlement entitlements following the sale of a business. The dispute related to whether funds contributed to Fast Wheels by Bob was by way of a loan, which would have been paid out as a priority, or a startup was it startup capital, in which case there wouldn't have been a priority. John was represented by another law firm which claimed that Russell Kennedy had a conflict of interest, as it had previously acted for John by incorporating the company, of which John was co-director, and had also drafted and settled Fast Wheels' shareholder and unit holder agreement. Can Russell Kennedy act for Bob?
So at this point, we recommend that you pause the presentation and have a discussion about the issues which arise from that. And we'll move on to the discussion points which this case study gives rise to. So, this case study picks up another rule in the Solicitor's Conduct Rules, this time Rule 10, conflicts concerning former clients. And in particular, it reads as follows. A solicitor and law practice must avoid conflicts between the duties owed to current and former clients, except as permitted by Rule 10.2. Rule 10.2 provides a mechanism whereby you can act where you're in possession of confidential information, but you first have to follow a couple of protocols. You cannot act unless first the former client has given their written informed consent to the solicitor so acting, or secondly that an effective information barrier has been established. So in terms of how that would be considered in practice, having regard to this case study, the LIV Ethics Committee was asked for a ruling. They said this: the first firm is conflicted on the basis of the duty of loyalty owed to a former client, which restrains a practitioner from preferring one client over another, and on the ground of safeguarding the due administration of the principles of justice. In those circumstances, the first firm should cease acting for that director in the dispute.
Personally, I think this is quite an easy case, because if you've acted for both parties in setting up a joint venture company, and then later on there's a dispute between the parties, it's pretty self-evident that you can't act for either party in that dispute unless, as Paul says, there's a relatively limited carve-out, and why would in any event the other client give you permission to act in relation to that contentious matter So I think this was a matter that the firm correctly bowed out of.
Yeah. And so the key points to take away from this particular case study, you need to ask these sorts of questions. Is there a real and sensible risk of the misuse of confidential information by the lawyer or the law firm continuing to act in the legal proceedings? Next, is there any breach of the duty of loyalty owed by the lawyer or the law firm to its alleged former client? And thirdly, and finally, the reasonable person test. And this is something that has been adopted by the Law Council of Australia over many years. What would a reasonable observer think about whether it was contrary to the administration of justice for the lawyer or the law firm to continue acting?
The only other thing I'll add for the CLC sector is that your CLC may have acted for one of the parties to this dispute several years before. You shouldn't act in relation against that client unless you go through the same protocol.
Yeah, exactly right. Okay.
Okay, we now move to case study 3. Between April and July 2005, Russell Kennedy acted... Now, I've got to say these are fictitious examples. Russell Kennedy didn't act for Jeff Jones. Just a convenient way to make the point. In a dispute regarding the failed purchase of a property. The dispute was ultimately resolved without litigation. Later on, in May 2009, Jeff Jones incorporated JJ Pty Ltd, a sole shareholder director company. In April 2015, JJ commenced legal proceedings in the Supreme Court against Property Solutions Proprietary Limited in an unrelated matter for the recovery of a debt. Russell Kennedy lawyer Morgan began advising Property Solutions. Through his new solicitors, Jeff Jones claimed Russell Kennedy was conflicted in acting against JJ's interests since it held confidential information obtained from him during the earlier retainer. What should Morgan do in this circumstances? What ethical issues arise? So what does Morgan do? Paul?
Rings you.
Thanks for passing it back.
So what this case study is intended to focus attention on is the confidentiality, the scope of confidential information. Typically, confidential information is understood to be corporate information, business information, personal information to individuals. But over the years, the courts have found something else, and it's what they call the getting to know you factors. And the getting to know you factors were first described in a case in 1998 in the Supreme Court by Justice Gillard. And what he said was this: in considering what constitutes confidential information, the relationship between solicitor and client may be such that the solicitor learns a great deal about his client, his strengths, his weaknesses, his honesty or lack thereof, his reaction to crisis, pressure or tension, his attitude to litigation, his attitude to settling cases, and his tactics. These are factors which I would call the getting to know you factors, the overall opinion formed by a solicitor of his client as a result of his contact may in all the circumstances amount to confidential information that should not be disclosed or used against the client.
Again, this builds very much on case number 2, doesn't it, Paul? It's again, I think Paul asked the question for case 2, what would the reasonable person think? Well, I think the reasonable person would think this firm shouldn't be acting in litigation against their former client.
Yeah. So some of the issues that emerge from this particular case study, what about the afflection of time? The firm acted many years ago. It's now 6, 7, 8 years.
And Morgan may not have been at the firm. Morgan may know nothing of this.
So there are different considerations in relation to the timing. Is
so
it
again,
real?
it's not black and white, is it?
It's not black and white, and it's a relevant consideration. Whether information concerning a former client is confidential is determined according to the facts and circumstances of each individual matter, by reference to the former client themselves, the information in question, the legal services provided to that client. It's always important to bear in mind it's not information per se that is protected for this purpose, but confidential information. Information that was once confidential may lose that status and may no longer be confidential, or it may not be material to any use that might now be proposed to be made of that information. Further, the so-called getting to know you factors might be well known. Particular personalities might have a high profile, and it might be widely known what their attitude to some of these matters might be. And so it'd be very hard to suggest that that information is confidential in those circumstances. So they're the sorts of considerations you need to be thinking through in making a decision about whether that applies in this case or not.
Yeah, and I thought Justice Gillard's observation that knowing the attitude of the former client to litigation and how they're likely to settle it is a very important consideration. But as Paul said, if that's generally known about that person, maybe it's not significant. But if it's not generally known, it's an important factor.
That's right.
Okay. We now move on to case study 4. Sharp lawyers hold a paper certificate of title to Joan's house. I'm not sure that this will happen too often in the CLC, but it does. There is a point to this example. And we now, as you know, we're in the electronic world of conveyancing. Joan is now represented by Russell Kennedy and wants to sell her house. She asked Solomon at Russell Kennedy to retrieve her title back from Sharp lawyers so that Russell Kennedy can start preparing a vendor statement and a contract. I had a request like this week. Solomon writes to Sharp lawyers enclosing a signed authority from Joan for the release of her title. You'd think that should be pretty straightforward. They email him back and say that the registrar's requirement now for paper conveyancing transactions require the verification of identity of Joan must first be undertaken before they can release the title. And this is VOI, as you may know, and I'm sure that you would have confidential documents at CLCs, is become a real touchstone in relation to releasing documents, because without the VOI, how can you be sure you're not releasing the title to the right person? Solomon, not our Solomon, it says here Solomon cracks it and replies that the client authority is sufficient. But is he right?
So, is the written client authority sufficient? So what we suggest is pause the presentation here for a moment, just have a think about that issue, and then when you resume, we'll take you through some of the discussion points and concepts. So, the things to focus on here is the client written authority sufficient? If not, why not? If it is, in what circumstances could it not be sufficient? So, in this particular instance, the LIV Ethics Committee was asked for a ruling on this point, and it was really a question about whether the registrar's requirements relating to conveyancing transactions extended so broadly that they covered all documents that might be involved in conveyancing transactions. So here's what they said. In the opinion of the Ethics Committee, the verification of identity obligations set out in the registrar's requirements for paper conveyancing relate to lodging dealings with the registrar. The verification of identity process is therefore not applicable to the transfer of documents from one firm to another. In this case, the law firm has provided a client authority to the other firm and other certifying documents relating to the release of the paper certificate of title and other client files. That is sufficient, and the other law firm is entitled to rely upon those and the credibility of those documents unless there's some reason to doubt the authenticity of those client authorities.
There's also a difference in this case study because it relates to releasing the title to another law firm. releasing to another law firm does have a lower bar on the VOI. If someone, Arti's sitting in front of us, our sole member of the audience, if Arti came to Russell Kennedy in 20 years' time and said, "You've got my title," we'd have to be satisfied it is Arti. If she came in her own right, not as a leading lawyer that she no doubt will be, or is already, but if she came to us then, we would have to go through the VOI process. But if she had her law firm at the time, Mallison's, write to us and say, "Here's an authority from Arti," we would have to release the document as the law currently stands. But we do have to take a lot more care, and anyone has to take care to make sure you're releasing confidential documents to the right person.
That's right. Okay.
Okay, you'll be pleased to know we're now coming to our last example. Case study 5. Russell Kennedy acts for Excellence International in relation to a dispute Excellence is having with one of its agents. Excellence provides educational services to domestic and international students who are sourced by agents with whom Excellence enters into agency agreements. The agents are paid a commission on the fees paid by the students that it recruits. Sharp lawyers act for the agents. The dispute relates to the terms of the agency agreement between Excellence and the agents. Russell Kennedy finds out that Excellence used to be represented by Sharp lawyers. It demands that Sharp lawyers ceases to act. Are Sharp lawyers conflicted? What factors could influence your decision? So you can pause there for the last time and think of your response, and we will now proceed with our views.
Okay, so what you need to think about in this sort of instance: the conduct rules, common law considerations, what else? So the starting point would be the conduct rules. Once again, Rule 10, conflicts concerning former clients. It's the same rule that we looked at in one of the earlier case studies, namely that a solicitor in a law practice must avoid conflicts between the duties owed to current and former clients unless you go through the protocols established by Rule 10.2 relating to obtaining written informed consent. So this particular case study was also the subject of an LIV Ethics Committee inquiry and ruling. And after due consideration, they said this: Sharp Lawyers is conflicted on the basis of the possible misuse of confidential information, a breach of the duty of loyalty owed to a client after the end of the retainer, and the appearance of justice ground.
I think also I had one other that came to my mind when I read this, and that is the fact that Sharp Lawyers may well have drafted the agreement that is in dispute as the former lawyers. Now, often it's ill-advised for a lawyer who's drafted an agreement to be involved in a dispute about the agreement, because unless the lawyer has acted in an exemplary way, there's usually some little foible or problem with the agreement, and that brings the lawyer into the picture. So that the last thing you want to do is have the lawyer acting for one of the parties in a dispute where their own conduct could become a consideration.
Yeah, exactly right.
I think that one's also we finished with a pretty straightforward one. And I think before we finish, I think Paul's got some really excellent takeaway points for you in relation to ethics, and I'll pass it over to Paul to wrap it up.
Yeah, thank you, John. So how do you absorb all of that and bring it to bear in your day-to-day practice? There's a lot of information. It's something that needs to be constantly at the top of your mind. The practice of law is difficult enough in terms of sorting out problems and devising solutions, but it's critical that there's this conscious overlay in all of our thinking at all points in time when acting for a client, that we have this ethical framework that we apply to what we do to make sure that we look after the interests of our clients as best we can. And so, based on these various case studies, there are at least 4 points to take away from this that I think will be of great value. The first is, make a habit of considering ethical issues right from the moment the file lands on your desk. It's often too late to do it when you're halfway through acting for a client. The damage could already be done by then. So do it right from the start. Next, conflict questions ought to be resolved early on, both for the client's sake and for the firm's sake. If there's a conflict that's not dealt with early on, then not only is the client potentially prejudiced, but the firm or the organisation, the legal organisation, can be exposed. Next, be alive to the possible consequences of changes in your instructions as a matter progresses. Sometimes ethical issues are not in existence at the start of a matter. They emerge later on. Frequently happens. Be conscious of it. It relates back to that point I made right at the start. Got to keep the framework in mind at all times. And then finally, when you're not sure, discuss it with an experienced colleague. These are rarely black and white matters. There are rarely simple answers, but there are always prudent responses and inappropriate responses. And what the goal of all of this is to guide us and help us to channel our responses along the prudent path rather than the inappropriate path. It's in the interests first and foremost of our clients, but also ourselves as practitioners and our employees.
Thank you, Paul. The next session was going to be questions, but unfortunately we only have Arti here at the moment. We hope very much next year to do this face-to-face after this crisis is over. We hope you're all keeping well through the crisis, remaining calm and heeding all the health warnings. And I do think, in fact, we have a question. Yes, over there.
Thank you. And in case I can't be maybe repeat.
No, yeah.
Yes.
What if you do have an ethical quandary and you speak to your manager and your manager's decision you don't feel comfortable with, you don't think it's the right decision? What do you do? Okay,
the question from Arti, a very good question, is Arti raises with her manager an ethical question, but she's not happy and comfortable with the response from the manager. I'll have my go first. Mm-hmm. It's your ethical responsibility, Arti. So you can't just let it sit there. If you feel that there is an egregious breach of ethics, you have to take it further. And maybe you should go to the Law Institute Ethics Committee or another source, because you can't just be you can't just simply say, oh, my manager says it's fine, I don't have to worry about it now.
Yeah, that's right, John. My first instinctive reaction to Arti's question was, well, now she's got 2 ethical issues. But not really. John's right. The obligation on us as practitioners is individual. We've all got our own individual practicing certificates. We all owe individual duties to clients and to the court and what have you. And they're all fundamentally important obligations and duties. And it's fine to have a discussion with more senior colleagues or managers or whoever it might be and take guidance from them. But if you disagree with their thoughts or their recommendations or their directions, it remains incumbent upon you to take further steps to try and find a solution or a resolution, and to keep doing that until you're satisfied that you've achieved that outcome. And that can be either by going through the LIV or through other conversations with other colleagues.
Okay, well, thanks for that question. We have one more question, yes?
How important would you say keeping good records of your ethical, quandary conversations with various people is?
Okay, the question from Arti is, how important is it to keep good records about ethical considerations that you've raised and you've considered in relation to a particular matter? Well, I would say it's the same as any sort of file hygiene. It's as lawyers, it's very important we have good file notes that of all relevant discussions and observations in relation to a matter, and it's no more or less relevant to ethical considerations.
Yep, couldn't add to that anymore. That's exactly what I'd say too.
Okay. All right, well, look, thank you out there, whoever you are. As I said, we very much hope we can do this face-to-face and make it a bit more interesting and interactive next year. And we promise we won't use the same case studies. We've got 12 months to work on some new ones. And all the best. And as I said, I hope you all keep well.
Thank you.